Okay, it is January 22nd, 2013. It's time for my legal update. In a couple of days, I'm going for Magistrate Jones for a stalking case against Ashley Redden, in which they're trying to justify the previous delinquency charges and the setup and everything from 7 years ago. Well, exculpatory evidence was on my computers that were seized, and they were concealed. They were taken on a threat of terrorism. And then when I was not charged with terrorism for a year, there was a whole thing about we found child porn on your computers, which I knew about because I had sent a statement to the West Virginia Crime Lab telling them they was going to find them, and that to look on my BlackBerry they would see an argument between me and my uncle where he had admitted to downloading the child porn on my computers. Now, the computers were taken April 25th of 2011. May 10th, 2011, I sent a statement to the West Virginia Crimes Lab, which I just mentioned. I found out after I was charged with the child pornography stuff that October 26th of 2011, a second search warrant was issued for the computers under the charges of child pornography, which essentially, according to Lieutenant Deeds, who said the computers were at the police station, means that they were removed from the forensics lab. As the forensics lab would have, video evidence from the recording on my BlackBerry. Now, that being said, and it also comes up rather interesting because Efred kept trying to get the passcode to my phone so they could prove that I was innocent, and my uncle did it all. But they shouldn't have my phone. My phone should be in a forensics lab in Charleston. So, I'm not stupid. Fact of the matter is, April 13th, 2012, after filing all these complaints and everything else, I talked to Captain White of the Office of Professional Standards and told him that if they did not do something about Lieutenant Deeds harassing me and me not being able to get the exculpatory evidence off my computers and all these other factors, that I was going to file a complaint with the superintendent of the state police. When I first filed a complaint on Lieutenant Deeds, I filed a complaint. When I first filed a complaint on Efred and him after talking to Lieutenant Deeds and recording our phone conversations, I filed a complaint with Captain White on Lieutenant Deeds. And then I filed a complaint on Captain White because I didn't believe he was going to do anything with the superintendent of the state police. This was a little bit proactive, but I did it for a very specific reason. See, this way, if I go and file another complaint with the superintendent, he doesn't have one complaint to deal with, but two. He has a complaint saying that I don't believe he's going to do anything, and then a second complaint confirming that he did nothing, which was filed. From jail, as a matter of fact. So, what we have here is on April 14th, they charged me with a child pornography case, and that's when I went through my preliminary hearing and found out about the second search warrant and everything else, which confirmed what I already knew, that they had taken the evidence out of the forensics lab, or not sent all of it to the forensics lab. And so we went through this. Well, because they really don't want to charge me, because if you were to charge me with the crime, because I would not give them the password to my phone, so they couldn't erase the argument between me and my uncle, where my uncle admitted to downloading the child pornography on my phone. And I should also point out that he's an informant, a very close friend to Deputy Jason Redden, who's related to Ashley Redden, and is by relation also the Redden, or more specifically, Deputy Redden is related to Trooper Williams, who is the brother-in-law of Trooper Duckworth. Close, and the Reddens are a close friend of the Lillys and the Kirks, who Daryl Lilly is married to Michelle Jennings, Mary Jennings' daughter. So it seems weird for Christopher Leffler to intentionally, during the delinquency case, file a motion to move it specifically in front of Mary Jennings, knowing there's a conflict of interest there. But anyways, so we go into this whole little situation. And it took me 2 years of fighting. I did 3 months in jail for the child porn thing, but it took me essentially 2 years of fighting with my attorney, Mingo Winters, in which it found out that he didn't even file a general motion of discovery, which shouldn't have mattered, should have still applied from when Jennifer Hewitt, my attorney before him, before she got disbarred for whatever reason, had filed. So it should have already been a precedence there. And the issue of my attorney, Mingo Winters, not filing that general motion of discovery causes a problem, because here's the problem. Okay, when you file a general motion of discovery, you are requesting habeas corpus, the right to see the evidence used against you. And in so doing, you are also obliged to turn over evidence that will be used in your defense. So the evidence that my attorney thought was gone, that was on the computers that were taken, I concealed from him, but the other evidence of where I had gone after the state police, and they were covering it up and threatening me with additional charges, as well as the phone records we had where it showed where Ashley had called me and a number of other things, essentially broke down to this whole issue of fabricating evidence. So what essentially happened is that, legal bullshit, but what essentially happened is that when we got rid of Mingo Winters, I took a psychological examination for the child pornography cases. It was my request to take a psychological examination. The prosecutor's probably hoping I was going to play crazy, which I didn't. I went in, explained things to them, and gave the forensic examiner a copy of some of the evidence that I had been holding on to that no one knew about. The same evidence which I had used in getting Mingo Winters fired that is sent to Judge Kirkpatrick and to Magistrate Jones and to the prosecutor's office. So they have no way of denying that evidence that was sent to them, they have it. Now, having that same material evidence given to all parties involved, Mingo Winters never showed up at the hearing to have him dismissed as my attorney. But, most importantly, this same evidence, which I must point out was material evidence, papers, photos, recordings, was given to the forensic examiner. The forensic examiner, after viewing the material evidence, placed his belief in my sanity and my innocence in the report. There are two questions which are asked by the prosecutor or by the courts to determine whether or not you are fit to stand trial or technically insane. In my case, well, I'm not crazy. The first question is whether or not you are criminally responsible. The second question being whether or not you are able to aid in your defense. See, if you cannot aid in your defense and you are not criminally responsible, then you are therefore crazy. And they can waive the trial and have you, locked up in a psych ward. So, what it essentially comes down to, and most entertainingly at that, is that the forensic examiner said that I was not criminally responsible after seeing the evidence that the prosecutor and my attorney and everything else had, which showed that I had filed complaints and the issue with Ashley Red and her prior contact with me and everything else, and that at the same time, the prosecution, at the same time I was able to defend myself in court and help in my defense, which means that it was the forensic examiner's opinion that I was innocent and sane. The prosecutor, therefore, Christine Keller, has requested that I have a second psychological examination, which I agreed to give me time to get my phone records. I'm going to come back sane on that one as well. The issue in this is that the police have a number of cases which have been brought before the prosecutor, and that implicating the police in any sort of setup or falsification of records against me would therefore also destroy any case the prosecution has against other people. Let's see the catch-22 in this. So they have to defend the cops for being criminals, otherwise they lose these other cases. The problem with that is, in so doing, where these officers are also connected to criminal activity, they become co-conspirators in said criminal activity. This is a direct violation of the West Virginia codes dealing with an organized criminal enterprise. So what we have here is a situation where I still don't have my phone records. I'm 2 days away from trial, and the prosecution is wanting me to take a psychological examination. I'm willing to do this because I'm going to come back sane. It doesn't matter if the guy says that I'm criminally responsible and able to aid in my defense. I'm sane, which just reinforces the previous judgment of the other forensic examiner that says I'm sane, and in his opinion, I'm innocent based on the physical material evidence, which the other forensic examiner will get the same thing. The prosecution already has it, the magistrate already has it, the judge already has it, Bingo Winters already has it, which is why I never showed up for the court case to have him dismissed. The issue behind all of this is, there's this hidden agenda behind things. And it sounds almost crazy to state this, but I mean, it's not a very hard agenda to figure out. People are trying to save their jobs, trying to save their careers, trying to save face. But they're doing so at the expense of my life, and I'm sorry. I'm coming for every single friggin' one of you. When it comes down to it, I don't have to resort to violence or anything like that to do so. In fact, if I wanted to resort to violence, I'd have done so years ago. I don't. I'm using a combination of passive resistance and the system where it benefits me to do so. Because if there is at any point in time, I do have to use force, and I do have to step that boundary from simply just beating up a cop to perhaps, killing one or something to defend my life. I want to have a record of the fact that I have resisted the temptation of using physical violence for as long as I could. That there's an extenuating circumstance to my need for defense. So there's a whole completely different level of issues in here, which is also a kind of a double-sided thing to my why I should own a rocket launcher video. The other side to that argument that I've actually already experienced, abuse and misconstruction of government power on a local level. So I don't see why I shouldn't have, some sort of firearms which allow me to level the playing field in defense of my own life. When the government says, the court system says I have a right to defend my life even from false arrest. So, I don't even want to go that direction, but if I have to, I like to have the option on the table. I really don't want to, but hey, all options are on the table at this point. I'm not going to make the first move in that regard anyway, so don't take it as a threat. The simple fact of the matter is, right now we're away from court. I'm not going to show up to court. I'm not going to have the evidence, and if I show up to court, I will make a statement before we get any of the proceedings. It'll be in my own words. It'll be quite simply that I feel that this is a violation of my 14th Amendment right to due process, that I've already been given a subpoena for these phone records. These phone records were destroyed in a fire which burned down a building, which is strange in and of itself. There's massive discrepancies in the child pornography case, which I'm not indicted for. That's right, I have not been indicted. So under Rule 62-2-12 of the West Virginia State Code, they have to dismiss the case due to lack of evidence. It'll be official February. But in conjunction with this, unless, of course, they try to push it through at the last minute because they're pissed off of me putting this video on the internet, in which case, too bad. It just proves my point. But also the fact that you also have this whole issue of false arrest, of the police threatening me, of me trying to get the evidence of being threatened. Because, like I said, October 26th, they got a second search warrant for the child pornography, but April 14th was when the warrant was issued for it. Only after April 13th, when I said that if Captain White didn't do something about Lieutenant Deeds and these other police officers violating my civil rights, I was going to the superintendent of the state police. So now you kind of start to see where everything gets kind of fitted together. And the issue with my phone records is that my phone records will not only prove that Ashley Redden had prior contact with me, that she's lying about being scared of me and all these other things, but that the involvement of senior FBI agent Michael Hayden, which has been dismissed, accused of conspiracy theory, me being crazy, whatever, can be proven. See, this is an active battle. that's going on, and they're trying to conceal the evidence as they're going because I'm not letting them know all the cards up my sleeve. And even the fact that me mentioning that this criminal organization can be exposed through my phone records, the denial of my phone records, the pushing through of the trial, denies me my 14th Amendment right to defense, as this is vital material evidence to my defense, even though it destroys their little criminal conspiracy and damages a lot of people's careers. It doesn't matter because we're not here to defend their careers. The prosecutor is not here to seek conviction. They're here to seek justice according to the letter of the law and the ideas that essentially have established the prosecution. The problem with this, however, is that they're not doing that. They're trying to force a conviction upon an innocent man to protect themselves, and that is misconstruction and abuse of power under color of law, which the prosecution is also responsible for. And because these cops are linked to criminal activity and Magic James is linked to criminal activity and everything else, what we come down to is that that defense of the prosecution based in good faith is completely destroyed. The police officer's defense in good faith is completely destroyed. And I'm just putting this out here right before trial because this is going to be interesting when I go to trial and say that, this is a fraudulent legal process brought about denying me my 14th Amendment right to due process of law because I don't have vital material evidence, because the prosecution is trying to cover up for the evidence and the other things which they don't want to have addressed. Most likely, they'll probably either give me my evidence or throw it out of court, in which case I'd much rather have my evidence. But I'll get my evidence when I file a lawsuit against the state, so I'll still get it, and it'll still get exposed. So either way they go, the only way they can win this is by convicting me. Even if they do convict me, I can still file a suit against the state through the federal court system and get a subpoena through the federal court system and still get everything I need. So, just interesting little thought for you out there. A little update on my criminal case.